Hello, welcome to Financial Insider Weekly. I'm your host, Michael Gray, CPA. My guest today is Charles H. Packer, who is an attorney with the law firm of Hopkins and Carley in San Jose and in Palo Alto, actually headquartered in Palo Alto. I've known Chuck for many years, and so that's what I'm going to call him, and he is our community sponsor for community television in Palo Alto. Chuck is the co-chair of the Family Wealth and Tax Planning Department at Hopkins and Carley. He's also a shareholder of the firm and a member of its executive committee. He graduated with his JD degree, which is the law degree, from University of Santa Clara in 1980, and was admitted to the California State Bar in 1981. The areas of his practice include estate planning, probate, trust, and estate administration, and also family businesses. Chuck also has Hopkins and Carley's legal services for the wine and viticultural industry. For the past several years, he's been the chairperson for the Jerry A. Kasner Estate Planning Symposium, which is sponsored by the Santa Clara University School of Law. Chuck and his wife Joan have 2 children, and he enjoys cycling, and he volunteers as a coach for the leukemia and lymphoma team in training cycle team. So Chuck, thanks for joining me today.
You're very welcome, Mike.
Okay.
Glad to be here.
Good. Today Chuck and I will be discussing whether a family trust should be terminated considering recent tax law changes and federal tax legislation that was passed called the American Taxpayer Relief Act of 2012. Back at that time we were calling it the fiscal cliff legislation, and its impact on estate planning. You might wonder, well, why are we talking about this 2 years later? And the reason is that people don't deal with their estates and trusts very often. They usually put them away and don't think about them for some time unless somebody twists their arm or otherwise encourages them to do so. So that's a little bit about, we want to bring up these issues about, maybe you need to be talking to your attorney about these issues. We want to caution you that this is only an introduction to complex issues to help become aware of them for a further discussion with an attorney or other tax advisor who's familiar with them. And the problems that we're discussing are complex, and there may not even be solutions to some of them. So here we go, Chuck.
All right.
Okay, well, what are some of those changes that were adopted in this legislation for which families should revisit their trusts?
Okay. Well, as you say, it was the American Taxpayer Relief Act of 2012, but as you may remember, Mike, the law was actually signed into law on January 3rd of 2013 and then backdated to be effective as of December 31st, 2012. The major components for you and I of this law were really, I think, 2. One, they made quote-unquote permanent the estate tax exemption amount at $5 million indexed for inflation. Mm-hmm. It's currently $5.45 million per person. And when I say permanent, what that means is, as with the prior law, there was a sunset. Mm-hmm. So it was slated to go out of effect after 10 years. This law does not have such a sunset, but it's really only as permanent as this particular Congress is. It can be changed at any point in time. So bottom line is we've got a $5 million index for inflation per person exemption amount, now $5.45 million due to the indexing, and the concept of portability. So previously, each of us had this exemption amount, $1 million, $3 million, $5 million, whatever it might have been, and if we didn't use it during our lifetime, it was lost. So it was a use it or a lose it concept. Hence, many families set up what we call the AB revocable trusts to capture that at the first death and take advantage of it through the surviving spouse's lifetime.
Right.
With the portability concept, we may not need to do the AB trust.
Right. So now what happens is if a person doesn't use that exemption, then the surviving spouse has what's left available to him or her.
Right. So, if, for example, a married couple had a $10 million estate, and at the death of husband, everything went to the wife. She was a U.S. citizen, so there's a marital deduction, unlimited. We haven't used his $5.43 million exemption amount. She has to file an estate tax return for the husband.
Right.
No taxes are due, but she has to do that to make the election for the portability. And then at the time of her death, she'll have his $5.43 million exemption amount plus whatever the exemption amount is at the time of her death. So conceivably, $11 million could pass, or just under $11 million, could pass estate tax free at the time of her death. It's important to note, though, that return does have to be filed to make the portability election.
Right.
And these numbers that I'm talking about, the 5.43 or 5.45, excuse me, also have to take into account prior lifetime taxable gifts. So if, in my example, the husband had made $1 million worth of lifetime gifts previously, his remaining exemption credit is really only $4.45 million.
Okay. Now, there are a couple other things to point up. So one is that the maximum estate tax rate currently is 40%. The maximum income tax rate before this legislation was around 35%, and now it's 39.6%. And the rate for long-term capital gains were increased from 15% to 20%. And if you think about that, that's pretty significant, increased by a third. And the other thing, though, related to these is that we have a very low threshold for trusts.
Yes.
So the maximum income tax rate kicks in when you have only $12,400 of income compared to $415,000 for a single person or $466,000 for married joint. So, it's quite dramatic, and it has an impact, again, because we're talking about whether or not we're going to continue having a trust that may be subject to these rates. And then we also have another tax, and it's not really part of that legislation. It's part of earlier legislation. It's the healthcare reform that was passed back in 2010. And we call it the net investment income tax. Some people call it the Obama tax. Anyway, 3.8% on net investment income. And this also applies to trusts at that very low threshold of $12,400. So anyway, when you throw all these together, we've got almost 44% federal income tax for these trusts. And so again, that's part of the reason why we're looking at re-examining them. Well, anyway, so why don't you go ahead and highlight some of the reasons why the changes are important for trusts?
Well, the thing to consider, Mike, is while estate tax minimization and postponement was a reason why many couples established the revocable living trust, the AB trusts, early on.
Right.
I still think there are plenty of non-tax reasons to retain them.
Yeah, we'll get into those.
Yeah, the control and the fact that you may not want the money to pass to the kids immediately and things like that. So, but you are. I agree with you. The discussion now has gone from purely estate tax to having to analyze the estate tax versus the income tax considerations of maintaining the trust, and whether the income gets distributed out and is taxable to the beneficiaries, versus capital gains on first death versus second death, and the step ups and basis. So there's a lot more number crunching now than there was before. And the analysis as to what the appropriate trust structure might be for a couple is actually tougher now than it was prior to the enactment of these laws.
Yeah. Well, it's like some people have said, I know for the very small estate, I know what to do. For the very large estate, I know what to do. It's the ones in the middle that's really problematic.
Right, exactly.
Yeah. Okay. So are all trusts subject to federal income taxes on their income?
Well, I mean, at this point, I think what we're talking about are the revocable living trusts. Now,
Yeah.
remember, while both of the spouses that set up the revocable living trust, also called a family trust or something like that, while they're both alive, the trust doesn't pay any taxes. It passes through to them. Or if an individual sets up a trust themselves, again, a revocable trust, that is not a separate tax entity so long as they're alive. All the income passes through to them. Once one of the spouses dies or the individual that set up the trust dies, the trust becomes irrevocable, or they possibly may have set up an irrevocable trust during their lifetime to make gifts to children and other people. Then you get into the situation where the trust is its own tax-paying entity. And as you just mentioned, those tax rates are quite high. We hit the maximum bracket at 12.4. There are ways to structure those trusts as what we call grantor trusts, intentionally defective grantor trusts, which pass the income taxes back to the person that sets up the trust, the grantor. In other instances, the income of the trust may be taxable to the beneficiary of the trust if it's distributed out to them. So basically 3 different scenarios in play: grantor, trust, or trust beneficiary paying the taxes. But one way or another, the government's going to collect some taxes.
Right, but we could have a lot different rate
Totally
schedule.
different scenarios based on all of those.
Yeah. Another thing is some trusts they have a provision that all of the income is currently distributable.
Yep.
And so in that case, the distributable income is taxed to the beneficiaries whether it has in fact been paid out or not.
Yes.
And but most of those also have a feature, I guess, that principal items are taxed to the trust. And so capital gains, for example, are usually considered to be principal items. Those would be taxed to the trust. And again, the tax rates are now higher much sooner for these trusts. We're talking 23.8%,
Right.
as opposed to maybe 15% at one time. So anyway, so that the income tax picture has changed quite a bit. Any other reasons to consider terminating a family trust?
It again, it depends on what the family dynamics were. If you've got a situation where the couple had wanted these 2 trusts because maybe they each had kids from prior marriages, I think you're going to have some issues if the widow decides she wants to terminate the trust and bring all of the husband's assets into her trust, and then maybe give everything to her kids upon her death. So
That's a good reason for keeping the trust.
Yeah, you have to keep it right. So you really have to look at the family dynamics and the situation for each family separately. There may be tax reasons to do something, but then you find out that the kid has a substance abuse problem or something. So that's a big red flag for me, and you can't let the tax tail wag the dog in that case.
Yeah.
You need that trust to protect the kid from himself.
Yeah. So we have some other things to think about in this. One of them is that some of these trusts have been around for a long time.
Correct.
And we've had much lower thresholds in the past for these estates where we set up these bypass trusts and so forth. And they have to go through expense. Each year they've got to pay CPA or somebody quite often to prepare the income tax returns. Or even if they don't, they have to prepare it themselves, and then they've got to deal with whatever risks if they decide to prepare it themselves.
Right.
Trusts are a little bit of a headache. In fact, when I initially set up some of these trusts, and I'm sure you've had this happen, we say when the trust matures or whatever, the first person passes away, and the survivor is floored when you say, okay, now we have to divide this stuff up, and now we're going to have a separate income tax return, and you have to be very careful because you have fiduciary duties related to these assets.
Right.
They are floored because they didn't really understand. You may have told them, tried to tell them very carefully when you set the thing up, but it didn't really sink in. And all of a sudden, here it is in reality, and they have to deal with it.
Right.
So if you have a very small trust, maybe it's just, eliminating a headache that's not worth it anymore.
Right.
Yeah.
That's very much a possibility of, maybe doing away with the B trust, the bypass trust, the one that the first spouse had.
Yeah.
That can be done in some instances if you've got the consent of all the beneficiaries and the fiduciaries, or in some instances you have to actually go to court and get the court's permission to do it. But there are, many reasons, like, you have to look at each situation separately. But in that case, one reason that you might want to do that is to get the step up in basis at the time that the surviving spouse dies, but it would have to be in his or her estate to do that.
Right.
Yeah.
So there are some of these trusts, and I had one. Actually, I've got some others, that some portion of the family residence is in the trust. And so, like you said, by distributing it out to the surviving spouse, you make it eligible to get the exclusion, the whole $250,000 for that person. May or may not be important, but as time goes on, it becomes more important.
Personal residence capital gains exclusion, yes.
Right. And then the other part is if they do hang on to it, that they'll get the step up in basis.
Correct.
And then the family won't have to pay any tax immediately after death if they decide to sell the place. So anyway, so those are some things to think about, reasons. So again, maybe we can go through some of the details about, do you have to go to court in order to terminate one of these trusts?
You have to look at the facts and circumstances, at the trust agreement, and at the family situation. If the document would allow for it, but you've got one outlier beneficiary, you're not going to be able to do it without court intervention or supervision.
Okay. So the chances are pretty good that you'll want to at least get a court to bless terminating the trust.
You probably would want to, maybe the current trustee who's the surviving spouse says, I don't really care. I'm going to do it anyway because if the kids don't like it, I'm going to be dead.
Yeah.
They can't sue me, I'm dead. But if it's an independent trustee, you or I as trustee of a friend or a client's trust, or a professional trustee, they're not going to do it without a court-approved termination because they want to protect themselves from future litigation.
And like you said, I mean, you may have, these days there are so many second marriage families. Right. And so if you have beneficiaries for each of the families that have an interest in these things, even if it's a surviving spouse, I think you and I would say, you have fiduciary duties here, you have conflicts of interest. Right. If you're going to try to go ahead with this, then really you should probably get some court approval.
Yeah. It's really unfortunate, Mike, and I know we've talked about this in the past. The increase in intrafamily trust disputes, the numbers is phenomenal. We actually have at our office 5 full-time litigators that do nothing but the family feuds. So somebody always feels that they got the short end of the stick, or that big brother didn't treat them right, or mom's doing something to favor the other kids. So it just makes, in my mind, a lot of sense to get the court approval early on to avoid the later headaches.
Okay.
So.
Well, now, let's say this trust is distributed to a life income beneficiary. Does the remainder beneficiary have to report a gift?
Very well might. You'd have to see again what the terms of the trust provided for. If the income beneficiary were entitled at the trustee's discretion to all of the principal in any event. I mean, there might be ways for the trustee just to distribute it out without even calling it a termination if it allows for all assets to be distributed. But if in fact, let's just say mom, the senior generation, was only entitled to the income of the trust for her lifetime,
right,
and not the principal, and the trust were terminated and she was given the accumulated income and the principal, the kids are giving something up, and there's an actuarial value to that, which may in fact amount to a taxable gift by them to mom. Yep.
Now, and it could go the other way. So the life interest beneficiary could release his or her rights, and so
Mom could say, I don't need it or want it anymore. Let's terminate the trust and have everything passed to you guys.
Right.
Could be a gift by mom to the kids, yes.
Yeah.
Yeah.
Okay. Okay. So you've hit a few of them, but maybe let's reiterate and think about it. Are there reasons? What are some of the reasons for continuing the trust in any case?
I think they're probably non-tax reasons. They are to protect the beneficiaries from themselves and others.
So we could have spendthrift provisions, things that basically
Right.
a creditor can't access the principal of the trust.
Right. We talk to our clients about having the trusts be held for the lifetime of their children, instead of what we used to do with a third at age 30 and a third at 35 and the balance at age 40. Because if it's in a lifetime trust and there is a subsequent divorce, the child and his or her spouse, we've got a better shot at keeping that family money if it's held in a trust than if it were held in the child's pocket. So definite non-tax issues for doing it. Maybe in fact the trust was set up, or the desire is that the children only get the income and the ultimate beneficiaries are going to be the grandchildren. Well, if that trust was properly set up, we're going to save one level of estate taxes, of transfer taxes, by keeping it in that trust, as opposed to terminating it, putting it in the child's pocket, only to have them then leave it for their children. So generally, Mike, I think it's the non-tax reasons that we're going to retain the trust as opposed to the tax, but there are some tax reasons too.
Yeah. So some people are worried that the way that Congress has been spending money and so forth, that there's a possibility that they may decide to reduce the estate exemption, in which case,
Correct.
In that case, we might be glad that we did keep the trust.
Right.
Yeah.
Right.
Of course, there are some families that have large estates, and in those cases, they're not going to want to terminate these trusts. So we said we know for the small ones, we know for the large ones, we don't know so much for the
ones in the middle.
Yeah. So I think we've covered some good ones. So is this a do-it-yourself job? You can terminate your own trust, no big deal.
Well, I don't. It's sort of like doing your own estate planning. I don't know if you remember you probably do, but some of the younger viewers may not. The television ads for Mr. Goodwrench. You can pay me now, or you can pay me later. So I think it's one of those things that folks that do this on their own may be, penny wise and pound foolish, that ultimately things are going to go, or may go sideways, and then they have to get lawyers in to do a whole lot more work than had they had the lawyers do it at the outset. So, it's like, do it at your own risk.
Yeah.
Yeah.
you think this might be one of those cases where we need more lawyers and not less lawyers? Should each family member get some representation?
Well, if you're asking different family members to relinquish their rights under that trust, they probably should check with their own lawyer. I'll be straight shooter with them if I'm talking to the whole family, but ultimately my obligation and my duty is to my client, which is generally the senior generation, and not to the kids. And even if we lay it out 100%, this is the plan, and this is how it's going to work, they still should, I think, go consult with somebody just to make sure that they're not leaving something on the table, or that they couldn't get a better deal some other way. Not that I think they could. There's only so much there for them. But if ultimately it's going to be a taxable gift by them to do something, or if they're relinquishing some rights, they should have their own lawyer to advise them on what they're giving up.
Yeah. I think the more significant the trust, the more important
Most
it probably
definitely.
is.
Most definitely.
And another thing related to it is that everybody just has to recognize that there can, particularly again when we've got different beneficiaries involved and so forth, that we've got conflicts of interest, and so
Yes.
So it may be that each person should be getting their own advice, and like you said, it's the penny wise and pound foolish situation,
Right.
And particularly for the trustee, because again, they have the fiduciary obligations. It's the fiduciary that can be sued when things go awry, in particular. So, anyway, I would think that if I was the counsel for that fiduciary, I'd say,
Right.
I think you better get some other attorneys to the table here.
Right. Most definitely.
Chuck, I want to thank you so much for joining me
You're very
as
welcome,
my
Mike.
guest to talk about this. It is a really difficult area, but folks, we wanted you to be aware of it and to see whether you should be revisiting your estate plan and these trusts that have been around for a long time.
Well, if I could just interject for half a second. In any event, you should be revisiting on a periodic basis regularly to make sure that ages that are specified are still what you want, that the fiduciaries that you've named in there are still appropriate, and just in general to make sure it still reflects your desires.
Okay. Folks, we're done. We're out of time. Thanks. See you next time.
Where was the clock?